A question I've been hearing with increasing frequency revolves around the security of retirement assets, specifically in the context of the legal turmoil surrounding Euroclear. With headlines dominated by billion-dollar lawsuits and frozen sovereign funds, it's entirely reasonable for individual investors to ask, are my retirement savings protected if Euroclear faces a crisis? This is a very valid question, especially in light of the widespread discussion about lawsuits related to assets frozen at the depository. The short answer is that, legally, your retirement assets are protected at a fundamentally different level than the sovereign assets or securities that are currently at the center of these international disputes. To understand why, we need to delve into the mechanics of how Euroclear operates and the legal firewalls that exist to safeguard individual investments. First, let's establish what Euroclear is and what it does. Headquartered in Brussels, Belgium, Euroclear stands as one of the world's largest and most systemically important international central securities depositories, or ICSDs. Its primary function is not to hold cash or retirement assets in the same way a commercial bank holds your checking account deposits. Instead, its core business revolves around the settlement, clearing, and custody of securities assets like stocks, corporate bonds, and government bonds for a global clientele of financial institutions and large-scale investors. When you, through your pension fund or investment manager, purchase a government bond or a share in a multinational corporation, Euroclear plays a crucial behind-the-scenes role. It ensures that the transaction is settled correctly, that the security is properly registered to its rightful owner, which could be your pension fund manager acting on your behalf, and that the integrity of the ownership chain is maintained. It is, in essence, a foundational pillar of the global financial plumbing, ensuring that securities transactions are executed smoothly and securely. The recent wave of concern and media attention directed at Euroclear stems not from its core operational functions, but from a highly specific and politically charged situation: the freezing of Russian sovereign assets. Following the full-scale invasion of Ukraine, the European Union imposed sweeping sanctions, which included immobilizing approximately $217 billion worth of assets belonging to the Central Bank of Russia that were held within the Euroclear system. These assets consist primarily of foreign exchange reserves and Russian government securities. This has predictably led to significant legal challenges, with the Russian Central Bank and other sanctioned entities launching lawsuits against Euroclear to reclaim these funds. This is where a critical distinction must be made between the types of assets involved. On one side, we have the frozen sovereign assets, which carry an extremely high level of risk at present. These are assets directly owned by a state entity, the Russian Central Bank, and have been targeted by international sanctions as a geopolitical tool. The EU has gone so far as to legislate a mechanism to seize the profits generated by these frozen assets, such as interest and coupon payments, to be used as collateral for financial aid packages supporting Ukraine. These sovereign holdings are now deeply entangled in a complex web of international law, political maneuvering, and high-stakes litigation. The outcome of these legal battles is uncertain and will likely set important precedents for international financial law. It is this specific category of assets that is at the heart of the current legal drama. On the other side, and in a completely different category of risk, are individual pension funds. Your pension, whether it's a state-sponsored plan or a private retirement account, constitutes your personal property. Legally, it is either owned directly by you or by the fund that manages it on your behalf as a fiduciary. This ownership structure is paramount. These assets are not national sovereign property and are therefore not subject to the kind of politically motivated sanctions that have targeted the Russian Central Bank/holdings. If your retirement portfolio includes investments in stocks or bonds that happen to be held in custody at Euroclear, the depository is merely acting as a custodian, safekeeper of your legally owned property. It does not hold ownership title to your assets. This legal separation is the first and most important layer of protection, insulating your retirement savings from the geopolitical disputes involving sovereign wealth. Now, let's address a more extreme, albeit highly improbable, scenario. What if Euroclear itself were to go bankrupt? While the failure of a financial institution of this size and systemic importance is considered a tail risk event, it's a possibility that regulators and legal frameworks are prepared for in the event of an insolvency. The legal process would be entirely different from the government-led freezing of assets we've discussed. The core principle at play here is the segregation of client assets. Under strict Belgian and EU financial regulations, institutions like Euroclear are mandated to keep client assets, such as the securities belonging to your pension fund, completely separate from their own corporate or operating assets. This principle of segregation is a cornerstone of modern investor protection. It means that in a bankruptcy scenario, a liquidator would be appointed to wind down the institution's affairs. Their primary task would be to clearly distinguish between the assets that belong to Euroclear's clients and the assets that belong to Euroclear itself. The securities held in custody for clients are not part of Euroclear's balance sheet and, as a result, are generally shielded from the claims of Euroclear's own creditors. Your pension fund's claim to its securities would take precedence. As those assets were never legally the property of the bankrupt institution. Furthermore, to provide an additional layer of security, EU member states have established various investor compensation schemes. These programs are designed to protect investors and depositors up to a certain limit in the unlikely event that a financial institution fails and there is a shortfall in client assets, a final backstop designed to maintain confidence in the financial system. In conclusion, while the headlines surrounding Euroclear might seem alarming, a detailed analysis reveals a clear distinction between the risks involved. If your pension fund is invested in assets like stocks and bonds that are held in custody at Euroclear, the probability of you losing those assets due to a Euroclear bankruptcy is exceptionally low. This is thanks to the robust legal and regulatory frameworks, particularly the mandatory segregation of client assets that are in place to protect individual investors. It is crucial to remember that the current legal risks, which are valued in the hundreds of billions of dollars, are overwhelmingly concentrated on the sovereign assets of the Russian central bank that have been frozen by government sanctions. These issues are distinct and separate from the personal retirement assets of European citizens and other international investors. As a final piece of personal advice, while the systemic protections are strong, proactive engagement is always a prudent strategy for any investor. I would recommend that you contact your pension fund manager or your investment bank directly. Ask them to confirm the specific custody structure of your retirement investments and inquire about the investor protection mechanisms they have in place. Understanding how your assets are held and the safeguards that exist in the event an intermediary custodian, like Euroclear, were to encounter financial or legal difficulties, will provide you with the ultimate peace of mind. In today's complex financial world, clarity and transparency are your greatest allies.